Townsend Planning Board. The time is 6:36 for the record. Recognizing that we have present in the room, myself as chair, Christopher Monroe, Francois Steiger, Alice Livedall, and our alternate member, Erica Dack. Present online, we have our member, John DeMalia. So, before we get into the meeting itself, we have a public comment session.
You need to indicate that it's public meeting.
Oh, yes, sorry. Planning board meetings are broadcast live and digitally recorded. This meeting is being held both in person and virtually through Zoom, pursuant to Governor Baker extending the COVID-19 rules allowing public meetings to be conducted remotely, so that board and committee members, as well as members of the public, can participate remotely. Public comment. This is specifically for things not on the agenda, which I do believe we have a person here for something not on the agenda.
Is that me?
Yes.
Oh, good. Mary Ann Pinto, 3 Oaks Environmental. I'm going to be working on the restoration of the clay pit at 26 Worcester Road, Alan Crane's property. I met with somebody from Natural Heritage who took me around the property, and I'd really like to show you folks what's happened out there over the years. And if there's anybody that would like to attend a site visit with me, I can give you the nickel tour that he gave me a couple of weeks ago. So, if you're interested in attending at some point, I have a calendar. And when's your meeting in September? There are 2 meetings, but it's the second one?
So we're actually gonna need to talk about that tonight.
Okay.
We have adjusted our schedule
Alright.
to be first Wednesday and third Thursday.
Okay,
But September is a weird shaped month this year.
alright.
So that would actually put the meetings 1 week after another, and there's 5 weeks in September. So I am later on going to suggest to the board that we actually push our second meeting back a week, pending some other discussions that we're gonna have this evening.
Which would be approximately,
Which would mean that we are meeting September 7th. By the calendar, it would have been September 15th,
but you're thinking 22nd maybe.
but I'm thinking the
Alright.
22nd would
Alright,
make
so
more
one of
sense.
those 2.
Yep.
And I would request to be at that one of those meetings, whichever one that is, in order to present what's happened at the pit and what remains to be done.
I very much would like that walkthrough, and I believe
Alright.
there are other members that are interested in it.
And
Did we have, I thought we had was it last year that there was a planned walkthrough that never materialized, correct?
Right,
Okay.
we never got it together.
Okay, and
But
sorry, go ahead.
the weather's better now, it's a good
Yes.
time.
Yeah.
yeah, things are growing, so you can really see what's going
Saturdays
on.
or during the week, or what are we talking about?
I could do during the week, in the afternoon, when folks are out of work, I could do the weekend too.
A weekend would be ideal for me.
Same here. So on a Saturday,
This weekend coming up, or?
no, this weekend coming up.
Or after Labor Day, cause
Yeah.
that week I'm
After
in
Labor
Maine.
Day.
And we're gonna have to post, because I think we're gonna end up with a
Yeah,
quorum
with a
of us
quorum.
there.
Yes.
So,
Okay,
um,
alright. I'm available Saturday the 17th of September.
Okay. So this would be Saturday the 17th, okay?
Say 10 o'clock, what do you think?
10 o'clock would be fine.
That's Hubbardston Field Day, but.
Oh,
Oh,
We
That's
can
right.
join the field day immediately thereafter.
Yeah.
no, I gotta be at the field day at 7:30,
Oh.
so I won't be joining you guys. Thanks, Ed. I don't know, that's a whole day and it's a big event, and,
Yeah.
I mean, if everybody else can go, it's fine, I just can't.
So what are we saying, 17th? Or are we proposing a
17th or
different date?
18th?
If it works for everybody else,
Like, the only challenge is if you have the meeting on the 15th, then it would be after it.
oh,
That would be the only challenge, and I'm in Maine until Monday the 12th.
The 17th would be the best with me. I coach football,
Okay.
so I get a lot of my weekends occupied by games, and I don't have the games that far in the season announced already. So that's what makes me hesitant to commit to something other than the 17th at the moment.
Okay.
that's fine, I have
Alright.
walked that property before, so I
Yes.
kinda
Okay.
understand it.
Okay, and I'll take some good pictures and have good information, so.
And did we suggest the time?
10?
10?
And I apologize, can I have your name again?
Mary Ann,
Mary Ann?
Maryann,
Yep.
DiPinto, D-I, capital P-I-N-T-O. It's Three Oaks Environmental. I'm in town. Okay.
We have a hand raised.
Hi, Chris,
Yes.
Mike Stahl, 5 Lombard Road. Could you just give us a landmark where this is located?
You know where Capri Farm is?
Yes.
They're just, this site is almost behind them, very close by.
Right next door practically, and, yeah.
So if you were going
If you're going
south
down-
on 68, is it on?
As you go down the hill, on the right-hand side,
Before you
before
get to
Capri
the farm.
Farm, there's
And
another,
before the river?
it
coming out
is
of
way
the-
before the river, it's before Capri Farm is the,
Oh,
is the
it's
prior
before.
entrance.
Okay. All right, thank you.
All right, you're welcome.
Thank you.
Can I ask, oh yeah, we do have it recorded here, okay, just in case there's anybody else who has questions.
All right, thank you very much.
Thank you.
you.
You're welcome.
If somebody puts a hand up, please let me know.
Yep, that's why I told you.
And anybody else for things not on the agenda? All right, well, moving forward, we have approval of the minutes from our previous meeting.
I'll make a motion to approve those minutes, the minutes of August 4th, 2022.
So, I was not at the meeting, I did read the minutes, there's no issues on my end, I concur with them, so I'm seconding them.
Okay. So hearing a motion and a second, any discussions or corrections? All right, let's have a vote.
July.
Steiger, aye?
Monroe, aye.
Demalia, aye.
Thank you. The minutes are accepted. All right, well, next on the agenda is continuation of the public hearing regarding 14 Main Street, the application by Vertex Towers. The town of Hubbardston is, that's not the right color, please. This one is. This is a continuation of the public hearing from July 21st, 2022. This continued public hearing is to consider the application for a special permit to construct a cell tower in Hubbardston. The applicant is Vertex Towers LLC. The proposed tower is to be located at 14 Main Street, Hubbardston, parcel number 08A041, with access to that parcel via 7 Brigham Street, 08A051, and 9 Brigham Street, 08A049. This meeting was posted and is being held at Town Hall, 7 Main Street, Hubbardston, Massachusetts, in the Slade Building. Recognizing for members present at this meeting, we have Francois Steiger, Alice Livedall, and our associate member is a voting member for the purpose of this, Erica Dack. And we have John Demalia attending online. Mr. Parisi, please identify yourself and give us an update of where you're at procedurally.
Good evening. My name is Francis Parisi, representing the applicant Vertex Towers LLC. As was read in the notice, I'm not sure if it was completely accurate. I believe we need a special permit and site plan approval for a telecommunications facility at 14 Main Street with access over 9 and 11. I don't think I have those numbers right. Brigham Road. I want to apologize for the last public meeting. I thought we were going to be able to see on the screen all my pictures and presentation, and because of some technical difficulties, weren't able to do that. So I brought a screen here. I got everything on the screen, and so if anything comes up tonight, I have the plans, I have photographs, I should have everything we need right here on the computer. So I think it should go a lot more smoothly. And one of the things I noticed, we were at the zoning board meeting the other night, and there's still an immense amount of confusion about that. And I think if people were able to see the plans, see the photographs, it might alleviate some of the questions and confusion that have stemmed from some of the previous technical difficulties. We are here tonight, hopefully getting a special permit for a telecommunications facility. As the board is aware, we met with you informally as required by your zoning bylaw back in February. We had filed the application back in April. We've had 4 or 5 procedural meetings before we had the first public hearing back in late July. And at the same time, we scheduled a concurrent public hearing in front of the zoning board. We were back in front of the zoning board 2 nights ago, and they've continued that meeting, but I think that's all resolved from a procedural standpoint. So we're here tonight seeking a special permit and site plan approval. Let's address the elephant in the room. At the last meeting, I was provided with a bill for $6,000 for a consultant. And when I raised questions on that, you sent me back, oh, it's really $11,000. I was in town hall today and I saw on the wall, all the fees assessed by the town. Marriage license, $100, dog permit, $100, variance, $100. I didn't see special permit, $12,500. And I just think I questioned it. I gave you an immense amount of information showing what we've paid to other towns under similar circumstances, and what I get was, no, we didn't tell you about that. So notwithstanding the fact that I've been in front of this board 6 times, the bill keeps going up every time I come here. And so we're ready to dispute that. I'm hoping that the board came up with some reasonable compromises. I have some reasonable solutions, but if we're not gonna move forward, I would suggest that you reject the application so that we can get resolution in federal court. I'm not trying to threaten, I'm not trying to, I have shown the town an immense amount of courtesy and patience, and everybody, including this board, has shown me an immense amount of courtesy and patience. Everybody in town hall has shown me an immense amount of courtesy and patience. Yet every time I come before this board, I get a different bill. So I'm hoping that you guys have some response to that that's far more reasonable so that we can move forward, get our special permit approved, get our site plan approved, and we can build our facility.
Okay. Thank you for that summary. The fee issue is something that it is the first thing we need to talk through tonight. I am going to read for the record what has happened from a board perspective. When we opened this meeting on July 21st, the board found out that the estimated amount for consulting services had not been deposited with the town. At the meeting, the applicant was presented with the estimate from the town consultant. At that time, the applicant entered into an objection to the board over the fee presented at that time. Since then, you did provide us with a list of fees that were charged by other towns that you've worked with. We took that list and we examined it. The list of communities presented had consulting fees ranging from $450 to $3,000. 4 of those communities were in New Hampshire and 1 was in Massachusetts. The Massachusetts community that was listed was Munson, and it was representing the highest price in the sample. The chair reviewed the numbers and looked at some of the situations. Munson is essentially the closest town to where we're at. It's Massachusetts. They operate under essentially the same legal framework. However, Munson also has a full-time community development director, so that is a place where there is some difference. So what we did in order to in an effort to be fair to you, we worked with the town administrator to issue an RFP to 7 firms requesting a quote, and made that RFP due today. As of the current moment, none of them have responded. It is possible one may have come in the last possible minute because they were due at the close of business today. It hasn't been forwarded to me. It was due to the plan at Hubbardston email address at close of business. I do not have access to that. So, you did appropriately identify that under state statute, General Law 44, Section 53, special permit granting authorities are allowed the imposition of reasonable fees for the employment of outside consultants, and that your dispute is ultimately based upon whether or not it is reasonable. Section 9.2 of our local bylaws does post that an applicant is to pay for all consulting fees for legal, engineering, or professional review as required by the planning board under the site plan approval process. Additionally, the published fee sheet for the planning board is available online and clearly states all fees incurred by the town of Hubbardston in conjunction with the plan will be at the applicant's expense and will be payable at the time of submission. The sheet further states a 15% administrative fee will be added to the engineering costs related to these transactions. I do hope that we can come to some kind of arrangement here. Personally, I don't think the fees from the other towns are equivalent to our situation, with the one being in Massachusetts and the one that was in Massachusetts has a community development director. And just from going through the proposals presented by Places Associates, looking at the hours that are assigned for specific tasks, and looking at the rate for those hours, those particular tasks seem reasonable. The tasks that are, the hours that are listed for those tasks and the rate that's billed for those hours seem reasonable. Where I think there's an opportunity to have a conversation here is if there's any of those tasks that perhaps we could potentially offload, because somebody has to do them. We're an all-volunteer board, and frankly, I took a day of work unpaid just to follow up on this for you.
I appreciate that.
None of us are writing your special permit. It is not happening. We are hiring a professional to do that.
Has the town not granted special permits before?
We have granted special permits before, but we have always hired a consultant to do them because we have always had somebody go through and come up with findings. And in a recent example, we were very happy that we had done that for a marijuana facility because the special permit actually outlines the complaint process for what happens if there's odor complaints. And we're now walking down that process now. So having somebody go through and look at that from our perspective to anticipate future problems, and in the context of your project, decommissioning processes and steps. I personally find that to be invaluable. So what I would suggest is we need to have a conversation right now and figure out if there's something we can do about it, or else I agree with you. And I believe the board is going to take the same position where we're just going to reject and we're going to have to sort this out from a legal perspective. I think that is a fair assessment of the situation. So with that said, I'm willing to make the first move on this in interest of being fair. I will suggest that the board waive the 15% administrative fee. I think it's fair and equitable from a couple standpoints. One being, we don't currently have administrative staff doing it. I'm doing it, and I'm an elected volunteer, so I don't get paid. So I think that's a fair, easy compromise for us to make. So where are we at from there?
I question the competency and the biasness of Place and Associates. It's my understanding the individual from Place and Associates lives in town, so has a bias inherently by being a town resident. Two, they are an engineering firm, and although they are incredibly competent at looking at drainage calculations and site plans, I don't know that they have the competency to look at a zoning bylaw or, and certainly not a telecommunications application. So what I would suggest is that the town, and then I have the issue of it was never disclosed to us up front. So what I would suggest is that the town reduce the scope of what you ask a consultant to do to just a review of the drainage calculations that we provided, that the town approve the special permit and defer review of the site plan approval until you get a consultant to review the drainage calculations. And that way we can move forward here. Because we also, I don't know that you're gonna approve it. So it just sure smells bad from our perspective when every time, even though you've had ample opportunity to disclose these fees, you haven't. And if you do it to every application, it should have been on the application itself. And so I believe that the more fair thing to do is to approve the special permit, engage a consultant to review the drainage calcs, which I suspect no one here on this board has the in engineering wherewithal to do, and that we defer decision on the site plan approval until the board has had an opportunity to engage a consultant to review the drainage calcs. And just, we asked for a deferral on the drainage calcs because we're actually creating a de minimis, we're not creating any new asphalt. And the board convinced us that that was a material issue in the town of Hubbardston. And I looked at your zoning bylaw and all the other provisions, and you give great deference to wetlands and watershed protection. And I recognize that, more so than any other town in Massachusetts, given the land use here in Hubbardston. So we provided that information. And then we get hit with another bill to review it. I'll agree to that. But I think the board is able to look at its zoning bylaw, look at the site plan that we did the site plan walk for, look at the application I provided, and make a decision on site plan approval, on such a special permit. And then the board has a reasonable time to draft reasonable decision under state law, and that we engage a consultant just to look at the drainage calculations.
Opening the discussion up to the rest of the board.
I'll kick it off. I just wanna say I was the planning board chair for the past 4 years. We did the storage lockers on 68, we did the 2 marijuana fields. They all had, I have to say that Bill Murray is a very competent person. He's really knowledgeable, he represents their firm places, represents many communities. So I don't wanna hear him maligned on the record. He has the knowledge, and he has helped us enormously. And he is aware of the pitfalls, and we have had in this part of the world, in Athol, for example, approved a solar field with minimum review. Huge rain came after they clear cut it, the road was completely closed. It was a huge mess for the town. So, need to err on the side of caution and to say, okay, we won't have him look at whether the foundation is really accurate, we won't, to your tower, we won't have him really check the fall distances, we won't have him really look at how really review that map. And I've reviewed that map from a layman's point of view, and it cannot be done in an hour. It's a significant task, even to just look at, to correct it. So, we did ask him, is there wiggle room here, can you do something? And he said, that's it. I think things are expensive these days. I think sticker shock, absolutely everything you look at, but he's facing a lot of those things too, right?
It's not sticker shock, it's lack of disclosure. If you knew from the storage facility, if you knew from the marijuana facility that it was gonna be a $12,500 fee, why wasn't that disclosed on the application? Why wasn't that disclosed on any of the pre-application meetings that we had?
Because
or
it is-
the procedural
Mr. Parisi, if I
application?
may, you have to understand that this is the very, very first time that we have a cell tower that is being presented to the town of Hubbardston. And so as a result of this here, every project is very different. And I can tell you that this is not a standard fee, that it's a $12,000 fee. When it came to the storage locker facility, it was a different amount. The marijuana was a different amount. As a matter of fact, we had 2 marijuana fields, both of which came back with an assessment by Places and Associate, both of which ended up having different amounts. And so as a result of this here, we cannot tell you that it's gonna be X amount of dollars. We really have to rely on the knowledge and the capabilities that come from Places and Associates, specifically Mr. Bill Murray, to provide us, based on the nuances of every single one of these projects, an assessment of what really has to be done. And as you very clearly stated, there's different bylaws that we have, or sections of the bylaw, and each one of them applies very differently. And in this particular case, because this happened to be in a location that required access through other fields and so forth, there was additional work. I will point out too that in his very first estimate, which he gave you, I think he actually came under. So he's a very reasonable person from that perspective. The bias that you mentioned, I just wanted to comment on this here, can work really both ways. As a most knowledgeable person and for somebody who is close by, I think that the bias is also can run in your favor, in the sense that he will give you an honest assessment instead of somebody who comes from the outside and really has no understanding or no knowledge of what we have in this particular town. So I do concur with what Mrs. Livedall has indicated, and that is I really want to make sure that we are not putting down Places and Associates when we say that they're biased. The last point I wanted to make here is that I understand that there's a risk that you're taking when you come to the board and you're paying a certain amount. And I'm saying that this is a gamble because I think we are very objective. We're looking at, and I think we have stated this here in the past to the broader public. We look at every single one of these projects based on the merit, based on whether or not they are coming, you're coming to us with a project that looks at the bylaw and whether or not the merits of your project adhere to the bylaw. And if there's any changes that have to be made, yes, obviously we're going to be using the input that we receive from Mr. Murray in order to be able to come up with a reasonable compromise. I will say though, and this is just something for you to consider being an attorney, you clearly understand the cost of litigation. And I would just ask you to rethink the threat of litigation and the cost that it incurs on yourself versus something that we can potentially come back amicably. And I think we have provided with the chair here the first way in which we can potentially come back and reduce some of the costs. The only thing that I would add to this here is we could theoretically also ask Mr. Murray to review his proposal and see if there's any areas where he feels like we may not necessarily have to go and count every single one of these paths and come back with something that may be more may reduce the cost. And I shall leave it at that.
I would be willing to entertain the possibility that we would continue to our next meeting, which would be the 7th, that we would invite Bill Murray and we would pay for his presence at the meeting out of the planning board expense. We would not charge it to your application. And that could permit us to have a conversation if there's any line items that we can push. For example, maybe you take a first draft at putting together the special permit. Maybe there's some options for that. Maybe there's some ways we can work together on this. I'm not unsympathetic to your position, but at the same time, I remain firm for the specific charge that we have given Bill Murray over the years. His fees are reasonable and his service to the town has been exemplary. The only question that we have here, I believe, is the scope of the review that we're asking him to do. I don't think we have a real dispute here as to his competence or the quality of work in his past. We have a dispute as to the scope of the review we're requesting for him to do. And I think we can potentially work through that. Is that something that you would entertain? Does that sound like a good step forward?
Would the board entertain approving the special permit? It'd be a lot easier to pay Mr. Murray if we had some assurance that we were going to get approved. But I believe that the board has the authority and all the information necessary to vote on the special permit. I understand there are drainage concerns. I understand there are road concerns, and I believe Mr. Murray is incredibly competent to review those. But the tower itself, the zoning bylaw, this board has the authority to look at. You guys were able to witness the balloon. You guys were able to do the site visit. You've had the application for 4 months, and so there's been plenty of opportunity to, and I'll continue to ask questions if you want to stay here tonight and answer questions. But I would request that the board approve the special permit, and then we can defer the site plan approval until Mr. Murray has a chance to look at the drainage and the road and those civil type things that he certainly has competency to look at.
So, personally, I would prefer to do that after having that meeting with Mr. Murray, potentially within 2 weeks, where we could talk about doing those things in detail, not where we sit here and do it as an abstract. Like I mentioned, we're volunteers. We've done 3 special permits in the last year and a half. That's about the depth of our experience here. So without that type of representation, or without having town council present, either of which we're willing to pay for out of our own pocket to have this conversation, I personally am not willing to entertain that ahead of time. Now, I don't know if anybody else on the board feels any differently about that.
No, I would concur with you personally, and, it's-
I just think it ought to be, I think we gotta know what he's really asking here. So are you saying, for example, you're looking for the board to approve a special permit conditioned upon a satisfactory site plan review, a satisfactory engineering plan review? And I don't even know whether we can do that, but I wanna
Well,
maybe
according-
make
it's
your
two-
ask
it's
clear.
two separate applications. I require a special permit and I need site plan approval. I agree there's some technical provisions in the site plan that, a volunteer board may not be able to answer. And certainly the drainage calcs, which, the town early on expressed, concern with respect to that there be no, issue with respect to stormwater runoff. But, you know, the other issue that we have here is that I applied back in April, and, we keep kicking the can down the road. And I know you're all volunteers, we got an incredibly thorough review that I thought was the end of it, with Mr. Murray's involvement, and I wasn't told that he was going to then review the application again after you already paid him to review it. So I'm confused as to what we're paying him for. However, like I said, we could take comfort in moving forward with Mr. Murray if we knew the board was going to approve at least a special permit, the big picture, and leaving some of the drainage details and engineering review to a condition of approval.
Chris, can I answer one question?
Yes, absolutely.
So the way this is structured is his first review, we don't have the world's greatest bylaws, and we didn't write them on this, you know, or review, to say the
Lament-
least, but all bylaws are complicated, but anyway, his first review is, does your application, without making any judgments on the merit, does it hit every criteria that needs to be addressed? And that's what that was about. It wasn't looking whether the material was accurate, looking at, you know, so there is a difference.
Look at
And-
it from my perspective. How was I supposed to know that? How were we supposed to know? We got a review and a bill, and we paid it immediately, cause we thought it was reasonable. And then we get two bills after that, are the bills gonna stop? How do I know, you know, it's not, it can't be carte blanche. There has to be some finality to it.
And I think that at this point in time, we can categorically indicate to you that, where we stand is that, this is it. This is what we need in order to be able to come back with a, with a final, version of this here. I do not see a requirement for us to engage Mr. Murray beyond this here.
So why not approve the bill, approve the special permit, subject to my paying Mr. Murray's $12,500 bill? And then I can decide whether that's reasonable or not. But what's not reasonable is to keep kicking the can down the road, keep providing me bills and not making a decision. The other issue that's going on here is that there's both state and federal law that puts time limits on these things.
We understand that, and the time limits have been very clearly stated in the bylaw itself, and I think we
And-
have 90 days.
If I may interject on this, we're well aware that there's a time limit. But it does read as 90 days from the date of the hearing. So even if we are to look at this conservatively, and we look at this as 90 days from when the public hearing opened, we're still well within that window. And the
There's
delay
all-
of the last month has been us trying to reasonably respond to your objection. So, I don't find the argument that we have been unreasonable in trying to help you, that has been a delay. That is unreasonable, because we listened to your objection and we immediately stopped doing anything that would run a bill towards you. We looked at the information you presented, and then we ran an RFP process to find out if there are other firms who are gonna come in and quote other prices. Is there a particular part of that strategy that seems unreasonable?
The deal that you offered me was that instead of marking up the 12,500, 15%, you'll reduce I take objection to 12,500, and you're saying, no, it was really 14,000 because we were gonna mark it up 15%. And so I feel like it's going up instead of down. And, and,
Well,
I'll pay the 15% if you approve the application tonight, subject to my paying the bill. But, I'm not gonna pay it and then have you deny it or have Mr. Murray find issues, because you've had plenty of time for that.
well, let's put this on the table. Would anybody like to make a motion to approve the application tonight? Mr. Demalia, would you?
No, not at this time.
I don't believe that the board sees that as a suitable solution. So I would suggest that what we've come to here is that we either meet again on September 7th with us inviting either town council, Mr. Murray, or both. Or else we call for a motion on this. So where are you at?
Where
are
am
you
I at?
this?
The downside of this all is I'm trying to avoid litigation. And however, by pushing it to September 7th, you have exceeded the federal limits with respect to the time frame involved in making a decision. So now I have to decide on September 1st whether I file a federal lawsuit. So, and I'm trying to avoid that. I'm trying to get a positive decision so that I don't have to litigate, so that I don't have to incur the expense, and the town doesn't have to incur the expense.
Have we been made aware that there is a September 1 timeline from Mr. Parisi?
No, we haven't, but just to interject for a moment here, I think we all understand your objection. We understand where you're at. I just presented to you two possible procedural outcomes, and in response, you threatened litigation against us. That was not an answer to the question. Are you saying that you would not like us to continue this to the 7th?
I asked for a decision, and you're not ready to make a decision, so the only thing you're going to do is continue it, and then I have to react to that.
So-
I'm still not trying to threaten anything here. What I'm trying to do is work patiently with the town, which we've done throughout this entire process. And I'm even gonna back up and say, I apologize for my tone, but it's incredibly frustrating because, I understand you're all volunteers. I understand you're having problems with staffing in town hall. I understand all that. But notwithstanding all that, we're not making progress. The bill went up today instead of down. I don't know what to do here. We'll ask Mr. Place or Mr. Murray to reduce his bill. What if he says no? What assurance do I have? What I asked the board to do was reduce the scope of what they asked him to do. And you haven't done that.
With due respect, we can't deliberate that unless we're in a meeting and we're in session. There's no way for us as a board to convene, to go through and talk about penciling the scope of an engagement. It's not possible for us to do without violating open meeting laws. So what I'm proposing is that we do exactly that. We're just objecting about when that happens. You would like us to do that right now. I would like us to do that with, I believe, town council now at this point, because you have threatened litigation, and with a representative from Places Associates. I believe that request is reasonable, because you have threatened litigation, and although Alice and I are both attorneys, neither of us are attorneys that represent the town, and we would now like to represent our right for counsel. So, I'm actually going to ask if anybody would like to make a motion to continue this hearing to the 7th, at 6:30, and that, we invite counsel and Places Associates to be present.
At this point in time, I would like to make that motion. And
And I will second that motion.
Thank you very much.
Point of one order. I understand there are members of the public here as well. And they probably want an opportunity to speak. Would it be prudent to let them speak? Because if they raise issues that the board feels is relevant to the discussion and to the decision-making process, wouldn't we wanna get it out the open now and not in October when, we finally get back, questions from Place and Associates? The other question I have is, the board needs to make a decision with council as to what they need Place and Associates for. So why does Place and Associates need to be at the next meeting? Because he's gonna say, we gotta do this, and this is a reasonable fee, and
If, I would like him to be available, that doesn't mean that we need to recognize him to speak. Being in the room and being available if we have questions is different from immediately calling him to the table and recognizing him as a party. Although I would like to point out that's not me implying that we don't trust the information that he's given us in the past, and I'm not making any slight against his reputation, but as a procedural matter, I believe that's true. I do believe you make a valid point, that we do have some people from the public that are here to comment, and that we probably should receive comment, because there are some that may not be able to make it the 7th. So I would ask if Mr. Steiger was willing to withdraw his motion temporarily, so that we could hear some public comments.
Yes, I would. I think we do have quite a large contingent of people here from Hubbardston. I think it is wise for us to do so therefore I do retract that.
Excellent.
Retract the motion.
Thank you. So there was a sign-in sheet that went around.
Can you please have that? Thank you.
Thank you. So do we,
I
if
don't think
possible,
we don't have anybody on Zoom other than John.
okay. If possible, I would like you to try to keep your comments limited to.
Wait a
to-
minute, I apologize. I do think that we do have other
Yeah, there are some
participants.
attendees.
Yes, I do see them now. So I think you may want to also ask the
Yep.
attendees.
So as a matter of process, I'm gonna take comments from in the room and questions from in the room first. I would like to suggest, please keep your comments to 2 to 3 minutes. We have a lot of work to do as a board tonight. We also have these procedural issues. We have some participants that are online. If you are online and you wish to comment, please raise your hand, but keep in mind we will go through the room first. All right, so.
And just for the sake of organizing this here, I do see that Mr. Parisi is one of the attendees, so we're not including that. But I do have 2 additional members, Krista Gogan and Tom Johnson, so we'll go to them at the end.
Tom Johnson is the civil engineer for Vertex.
Okay? We do have 1 person by the name of Krista Gogan.
All right, so let's look at the list here. So, for comments, do we have any comments from Ms. Southwick?
I wasn't, but I
Well,
do
you
have a
don't
comment.
feel the need to comment if you have to.
Well,
I guess I can
first
just do
wanna
a call of
thank the
hands,
board-
but
Thank the board, I've learned an awful lot of what you do, and it's beyond my wild imagination.
Thank you.
But if you're taking comments tonight on September 7th, does that mean we can come back?
We would we'll also look for questions and comments in the public hearing.
Okay, I'm just wondering if we're just kind of
Yeah, if.
wasting your time.
I suggest if someone has already commented, or if they intend to comment again at the 7th, it's not unreasonable to hold off on that, but I'm not gonna stop anybody from talking tonight or asking questions. So I guess, just for the sake of being more efficient here, how about show of hands? Who?
For comments?
Yes.
Comments
I'm
tonight.
sorry, someone coughed and I didn't hear what you said, so we can ask questions now
Yes.
and also on the 7th?
Yes.
Okay.
So show of hands, who would like to comment or has questions?
Mr.
Yes,
Blanchard?
please identify yourself
Edward
and your address for the
Blanchard,
record.
23 East Common Pond Road. I guess just from listening what has taken place at this meeting and the threat of litigation, and the time frame that is suggested on September 1st, would one of the options be for the board to vote on the application and determine that without the due diligence that should be done on this, if we were gonna be put in a suit due to time frame, then maybe one of the easiest things to do is just have the board vote tonight and deny the special permit. Just saying that's an option.
Thank you for your comment.
Okay. The other is there an appeal process to, once a special permit is granted?
There is.
There is. I'm debating whether I feel comfortable answering something that qualifies as specific legal advice.
20.
Especially in light of
Okay.
the situation that we have tonight.
Just noting, Mr. Parisi said there is a period of 20 days.
20 days.
Yes.
And is that in Superior Court?
Yes.
Correct.
Okay.
Any other questions or comments for this?
Yeah, I'm
evening?
not
Oh.
finished. Sorry, that was just.
Well, we're clearly gonna run longer than 3 minutes, but go ahead.
One of the things that really concerns a lot of people is the fact that the balloon test was not done in accordance with the specifications. It's supposed to be up for 24 hours. It was up for maybe a period of something like 2 hours, and that didn't give a lot of people an opportunity to see. I think the board should ask that be retested, and I know you notified the whole town, but that went out with an error on it, and it said that it was for the town of Holliston. But I think more importantly is that the townspeople, especially the butters, have a chance to see the balloon test. I know that he's taken all sorts of pictures from here, there, and everywhere, but I think it would be fair to those abutters to be able to see that balloon test and not in the 24-hour period that's by specification.
So I would like to address that from a procedural standpoint and then allow the applicant to speak. The board did debate that issue, and we did look at what was present in the bylaw, and the applicant suggested that what was proposed in the bylaw was unreasonable. And looking at what was proposed, it was for a balloon to be flown for 24 hours. There is not really a lot of reason to fly a balloon in the dark. That's not helping anybody. It's the doing of a useless thing. So the board spoke about that and decided that that was unreasonable. The applicant then presented evidence to us, testimony from himself, and I believe there was testimony from his engineer. I'll let the applicant speak to that, about how typically the winds increase to the point in the afternoon where a balloon test does not become useful anymore because of the tendency for afternoons to be much windier than the morning. So based upon the information that was presented, the board deliberated over that, and the board made a unanimous decision that the balloon test as it was proposed was reasonable compliance to the bylaws as they are. I am hesitant, I am stronger word than hesitant. I don't believe it would be a good or reasonable practice for us to reopen the discussion on that particular issue because it was debated and it was discussed and we did hear evidence on that. We also have more than enough issues going on with this application. But if anybody else on the board has anything to add to that comment, if not, I'll hear from Mr. Parisi.
I can see where 24 hours would be unreasonable, because in the dark, nobody can see it, but certainly
I-
2 hours.
I need to give the applicant an opportunity to speak.
Sure.
I believe the chair accurately described the discussion that we had. One of the other issues is that we needed to mail to the town, so we had to pick a date well in advance in order to, and guess the weather. And that's a challenge in itself. So it was up for substantially more than 2 hours. It was up as advertised, but certainly was not up for 24 hours, as we discussed.
Can you just comment on how long the balloon was up for?
I'd have to look at the advertisement,
was
but it was like
9 to
9 to
2,
2.
wasn't it?
I was saying 9 to 2, I'd have to look at the ad, it was so long ago, but,
My recollection for that was also that it was up for 9 to 2, so I do
I
believe
mean, I
it
was
up.
there when it was put up, it was definitely put up, at the
Yeah.
time stated.
Yes, I was
I
also.
saw it at 11.
I think it was up to 2, and by the time 2 was rolling around, that balloon was really whipping around. So he was right about prevailing winds.
Right,
Yeah, I
but
don't
there
know
is a
whether-
procedure for that as well, that, you know, if it's too windy, then it can be redone, I think.
To speak to something that's been, I think, the core of our discussion tonight.
Yeah, I don't wanna,
is that there is a reasonable standard to be applied to fees. And we made the decision as a board that it would not be reasonable to have the applicant have to do it multiple days. And I guess there could be the suggestion that maybe it's up for 4 hours this day, maybe it's up for different, that wasn't reasonable, because the applicant has to pay for independent, if I'm correct, the applicant needs to pay for independent consultants to go out and do it. It's something that has a real tangible material cost tied to it. To address a point that also came up in some of the correspondence that we received, there were some questions about whether we can designate that a particular time of year be used for flying the balloon. That's not stated anywhere in the bylaws. And I believe as a board we were comfortable with what I believe rose to the level of penciling, but we're not comfortable with just the creation of arbitrary terms. I don't know if anybody on the board feels any differently about that summary.
because I've talked with many of the abutters, and many of the abutters, did not have an opportunity to see the balloon, and some of them are here tonight, but, that's my request. We'll move on.
It's unfortunately an imperfect
We'll
situation.
move on.
I have given you a fair amount of time.
Do you wanna
and-
go to them and come back?
Well, I would like to recognize Mr. Stoll behind you. He's had his
Yes,
hand up for quite a time. Please
Chairman
identify yourself.
Monroe, Mike
Please
Stahl,
identify.
5 Lombard Road. I'm not an abutter, but I did take advantage of the opportunity to view the balloon. I did see it, it was afternoon. I may even have taken a photo of it. If you tell me the date it was flown, I'll go back and look to see if I've got that. And so I know that it was flown in the afternoon, because that's when I viewed it. And it was a bit of challenge to see it, not because the balloon was difficult to see, it's because you have to be in an area where you can see it. The whole point of this is to show whether or not you can see the tower. You'll be able to see a tower in the future. I had to walk up and down Main Street and look between the trees, and then I saw it at one point. And if I did take a photo of that particular spot, you know, you can probably recreate what the view was that would have allowed seeing a future tower there. And I did go up to Mount Jeff and look for it up there, and I can't remember the results of that. Thank you.
Yeah, thank you. I would like to take this moment to address a concern that was expressed to us in correspondence, and to also clear the air on a particular issue. The question was raised through correspondence from a constituent. Will the planning board consider the approval of a special permit for construction of a cell tower when the town, through reasonable dispatch it, is constructing its own tower on town-owned property? Why was there not a hearing on that tower? And to answer that from a procedural standpoint, the municipal tower was exempt from zoning and planning requirements, so there was no test and no hearings. The planning board had no authority over it. Additionally, It's my opinion, and I believe it's a unanimous opinion across the planning board, that the planning board, should not be considering that as a factor for this application. It would be fundamentally unfair, and it's not something that's mentioned in our zoning bylaws, as a standard for a special permit review. So that is not something that, that we will be considering as an evaluation factor in this process. There's a lot of stuff to read on this issue. If there's specific examples, please contact the office. We'll make a point to provide you with information. But to thoroughly answer that on the record, that is not something that we can consider as a planning board. Before I get to you, Ed, I'd like to see if any of the members of the planning board would like to comment on that issue.
No, I think you said.
There is
point
case
blank.
law where towns have
Yeah.
tried to say, we don't want the tower there, we want it here on our land, cause we wanna derive the revenue from that. In the town of Sudbury, there was a case. It was pretty, the tower won the case, and the town lost, even though the town said in its decision, well, we're really doing this because it has an impact on views, the town will cover the same spots and so on. I mean, it was pretty, it's sort of like thinking if you come to town and you plan a restaurant and you follow all of the guidelines in the zoning bylaw, for the board to say, well, we like your restaurant idea, but we like the competition better downtown, it's just something, it's not likely to prevail in the courts. If we were to say, we don't want this tower here because the town's gonna do something about the cell problem. And also, the town has not come to us and asked that. The town hasn't presented anything to us except 3 years ago it's planned to put this tower up. So as you can see from his plan, somebody fitting up these towers also involves buildings on the ground, a lot of other things, so it isn't properly before us, and it has never properly been before us. And I think it's important to understand.
Thank you.
But does it have to be before you?
Yeah,
No,
If it's
because
an-
they're an
right,
exempt,
So,
it's an exempt
yeah,
municipal use. It probably wouldn't have been allowed under the zoning law that's there. But I haven't matched it up. I don't know the fall distance. It's considerably taller tower. It's 200 feet, cause it's designed to cover 5 towns, not just the center of Hubbardston, right? So we had no say about it, but the town had a say about it. The town voted for it at an annual town meeting.
Thank you. But the summary is it's not a decision factor, and it cannot be a decision factor for us. Ms. Porter, please identify yourself.
I'm
and
Sarah
your
May
address.
Plord, I'm 80 New Westminster Road, but once that tower is up, which is supposed to be at the end of this month, of September, fire and police dispatch will be enhanced, and residential cell coverage will also be enhanced. So how could that not play into, can you just explain that to me?
Yep. As of the current moment, there are no spots that have been leased on that tower.
But the,
There is, the tower's primary purpose is for municipal communication. There are individuals in the town that have expressed the interest to attempt to rent space on that tower. There's no lease agreement, there's no proposal on that, there's been no RFP, there is no guarantee that any kind of commercial cellular equipment will end up on that tower. That is the current state of it. Yeah, there could be commercial equipment that ends up on it, there could be bidding. We've heard testimony from the applicant, and I'll give him an opportunity to speak, that the commercial carriers tend to not want to hang their equipment on municipal towers, even though it is possible. But the existence of that tower does not automatically mean that there will be an improvement in cellular reception because it is being set up primarily for radio use. I will come back to you, but I'd like to give the applicant a moment to respond on that.
I am not here to give the town any sort of legal advice. However, I question whether or not the town is exempt from its zoning bylaw. However, I don't really care. But I do care about your wireless bylaw. And it's very clear, you have a very extensive wireless bylaw that you want to engage a consultant to review. And that hasn't been done. That tower will never be used for commercial purposes because it wasn't built in compliance with your wireless bylaw. It would require an immense amount of variances. I, quite frankly, didn't even consider it as an opportunity until it was raised at the zoning board 2 days ago, and we've done an immense amount of research. It doesn't meet setbacks, it doesn't meet the height limitations, it doesn't meet all of the other, it's not in the wireless overlay district. So there's no way that any commercial carrier could go on that tower without coming to the planning board, without coming to the zoning board, and would require umpteen variances. So the town can do what it wants for public safety purposes, but not for commercial carriers.
I'll come back to the side of the room, Ms. Blair.
So, what I understand, and I have correspondence here that I'd like to give to you between Ryan McLean and I understand he's not an acting town administrator at this point, but this is when he was. Do you want this for the record, or?
Yeah, I'll receive it. I do believe it's already been sent and entered into the planning board record, but I'll
Okay.
take a copy. Thank you.
So and it's the information that I'm about to say is in that correspondence. They can't send out the RFP until the tower is actually built. It is primarily for fire and police, but the secondary use is for commercial carriers. In fact, there are 4 spots that were created for that purpose. And yes, it will enhance fire and police, but it's also meant to enhance residential coverage, and most likely will. So it would make sense that once that tower is up and running with commercial carriers, to have the town reevaluate where the gaps actually are in coverage, and even identify if there are gaps at that point. And I know that Alice, you were just talking about, I'm sorry, is your name Alice?
Yes.
You were just talking about the Sudbury case and how, I think were you speaking to redundancy, or when you said?
No. I'm just trying to say that in that case, it was very clear the town wanted the business. It's a very convoluted case. They actually, you can read it, but it's like 17 pages or something. But the gist of it is the town wanted the revenue and the location for itself. And they declined the cell tower provider, but they wrote an opinion that was disingenuous, that said we're really declining, from the court's point of view, made that determination, that actually the cell tower that was proposed, the commercial cell tower, did not have a tremendous, did not have a really onerous impact on the views, and that without it, there wasn't adequate coverage in the center of town. And also the town wanted to derive the revenue from those leases. And it would just, I mean, you have to consider this case because it's not that far from our facts. So you can read it, but that is we do have a case we have to consider. And what they tried to do was actually, steer the business towards the town on the grounds that it was. And in that case, the town was, I mean, his point is well taken too. In that case, the town was actually building a tower that was, intended for private cell phone users, not just municipal
Yep.
So can I?
people. But it is
Yeah.
maybe true that if a cell phone provider comes in
So,
and they wanna do business, they have to apply for a special permit, cause that's the only way a private provider can do it. I mean, a commercial company can
So-
do it, and they wouldn't meet the criteria I mean, that seems logical to me, it's just something I hadn't thought of, because of the fall distance, everything he has to meet. They didn't have to meet any of it because they were an exempt municipal use.
Thank you, Alice. To round out the conversation on this, we ultimately have standards of review, things that we have to look at for granting an application. We look at compliance to the bylaws. We look at impact to the community. The idea that there's this municipal tower or there's another tower, in my personal feeling, is not something that falls into that standard of review. I don't believe it is something that we can factor, and I understand that you feel differently, that you believe Ryan has made that position, but
But I have some,
with, please hold on.
sorry.
But with due respect to yourself and to Ryan, we're on this side of the table, and we're the ones who are forced to make the decision and have to live with the consequences. Ryan's not the town administrator, he consults. He's also not an attorney, he's not town council. He can't speak to any of these issues with authority, all he can do is express a personal opinion. And in the same regard, we as individuals can talk about it and how we feel about it, but unless we make a statement as a board, it's not speaking with authority. So I'm saying, and nobody on the board is objecting or stating a countervailing feeling, that this is not within the scope of review that is permissible for us on this project.
I understand what you're saying.
Okay.
Can I ask a couple questions,
Yes,
follow-up questions?
absolutely.
So, part of, I just wanna make it clear that I want enhanced cell coverage for this town. But 14 Main Street, I think, is, going to affect the landscape, and you just mentioned that. And I think it potentially will have an adverse impact on the abutting property's, property value. Are you taking those into consideration?
Yes, those things are within our standard of review, and when we make our decision, we'll consider those things.
So, can I ask you, I'm sorry,
We have given you quite a bit of time so far, so I'd ask you to limit to one more comment, please.
okay, so Rosemary was at the July 21st meeting, and she brought up an interesting point about whether, if the 14 Main Street tower becomes obsolete or irrelevant, is there gonna be a provision in the application, where the applicant has to give some sort of bond or escrow in case it becomes obsolete and needs decommissioning?
Yes, we will be looking at decommissioning processes. I can't remember if our bylaw had a specific bonding requirement.
It does have a bonding
No, it
requirement.
does have a
I believe
bonding
it is the
requirement.
case,
And we would
yes.
need a
So-
decommissioning plan.
Yeah,
There's a
so-
cash surety of $25,000 that is payable to the town treasurer of the town of Hubbardston for that purpose.
Yeah, we do similar things with solar fields, and not just us, other towns. It's standard process to do similar things with solar fields, gravel pits, those kinds of things. So those are issues that we do think about and we do contemplate.
The one thing I'm gonna interrupt here is I checked online about dismantling the tower because it can't be used. So you're talking about the use and $25,000. Well, recently, within probably a year, there was a town or an owner, it was up to the owner to take the tower down. And it was $70,000 to take it down, and the owner couldn't afford it. So there it sat.
Okay.
That's my concern, because you are in the center of a town.
Well, we will certainly consider that. If you have specific evidence to that, please submit it to the office. But decommissioning is something that we absolutely consider in the process. I do need to start moving across the room though, because we've got a bunch of people waiting patiently, and I'll come back to you. There's been hands behind you. I believe Mr. Walker,
Yeah,
please
just have a quick
identify
statement
yourself.
on the tower across from the pallet company.
Yep,
I'm
please
on-
identify yourself for the record. Name and
Peter
address.
Walker, 25 Muskogee Ave.
Thank
I am on a committee for the intermunicipal agreement for that tower. I'm
also a select board member. I'm not acting in that capacity right now, but we don't actually own that tower, the town. Did you know that?
Are you talking to me?
Yeah,
Please,
everybody.
please address the chair.
I'm sorry, sorry, Chair. We don't own the tower. Rutland Regional Dispatch owns that tower. The town owns the land. I'm just making it clear.
That is correct. That is how it was stated to us when they originally met with us.
Yes.
It is actually being utilized by multiple towns for public safety purposes.
Yes, 5, yeah.
Does that suggest that commercial could not go on it?
I haven't gotten to that point. I've only been to one meeting. The next meeting's next month, and I can finish that. Fall back.
I think one of the things to, when we're looking at commercial for that particular tower, that has been very vaguely discussed, and I think we're in no position as the planning board to discuss this here, because we really are not knowledgeable enough on that. And I think we all have different opinions, or maybe different ways of looking at this here.
Well, I can give you a quick update on the tower, cause I've been,
Very quickly, and then
Quickly,
I'm
right.
actually gonna close not the public hearing, but discussion on this particular
Yes.
issue, because I
Okay.
believe we've pretty thoroughly exhausted.
I've met with the supervisor many times who's doing the project, and he's on schedule to complete it by the end of by the end of September. And certainly RFPs could be put out in October, and those RFPs might be for free to have four carriers there. Will the tower support 4 carriers? This tower is huge, and will easily support 4 commercial carriers according to the supervisor of the job. And he says that even the equipment, the new equipment we have today is far lighter than in the past, but he said it definitely will support 4 commercial.
Okay, so
Let me-
with that said, I'd like to, I will not stop somebody from expressing their opinion in a public meeting, but I will like to suggest that, I consider this issue, resolved, because we thoroughly talked about how it's not something we consider in the scope of our review. It's not proper. The board feels unanimously about it. There's been no objections. So I would like to see if there
Could I
are
make a
further
comment
questions and
why
comment,
I think that may be
but
proper?
not on,
No,
you
no,
can
no,
absolutely
no,
comment,
no.
but not on that issue. We're done
Right.
with that one.
In our, you said our bylaws don't, have anything to do like that, but under 18.3, protection of the town from the effects of uncontrolled proliferation and placement of wire communication towers, personal wireless service facilities, and their accessory structures.
I'm gonna pause you for a moment, Ed. Those exact words, uncontrolled proliferation of towers, are literally the quote that comes out of the case that Alice was talking about. Which is why, one of the reasons why this cannot be a factor of our decision, and how we unanimously don't believe that it will be part of our decision. So I apologize to have to cut you off like that, but I do need to end this particular discussion, or else we're all gonna be here till midnight. I would like to ask if there's any additional comments on other issues.
I have a question.
Yes.
There's Michelle Lovell from 5 Maple Avenue.
Is that you?
There's a section in the application where the applicant is asking for a waiver for section 12.4.2D of the town bylaws, which is the fallback requirements. So, or fall zone requirement? Setback requirements, I'm sorry.
Setback.
Why do we need a variance for a setback requirement, and if so, whose property is it too close to?
I'll let the applicant respond to that, if you may.
I don't believe we're asking for a setback waiver.
Yeah, I
It's
believe there was a
specifically stated inside the application for the cell tower that I got from the town.
I believe.
No, it's some confusion in your zoning bylaw. There is some confusion in your zoning bylaw as to whether or not we have to build a lattice or a monopole. And there was, a waiver provision in your zoning bylaw that was attached to the setback clause. we meet the setback. However, you could interpret the zoning bylaw to say that that waiver provision was only permitting to the setback or to all other provisions of the zoning bylaw. And that's, so we applied for a variance, we applied for a waiver, and we're looking for a determination from that. Because your bylaw seemed to have been cobbled together with many different bylaws. You can build a lattice, you have to build a monopole, and I think we had talked at earlier meetings that the board was inclined to grant the waiver rather than requesting a variance from that provision. We're not, we meet handily all required setbacks.
I do believe that is a correct summary, that the applicant gave on that issue, that it is related to the structure of the tower itself. And the procedural summary was also correct. I don't know if anybody on the board have any other feelings on that? All right, further comments?
Actually, I've got some questions because there aren't any kind of actual specifications listed in the application. There are a lot of things that like you can't find. So like I would like to know exactly how far this tower is from my front door. Because I do believe I'm the closest, or maybe the second closest house to this tower. And
There are some plans there. I believe the applicant might be able to answer that question, or at least point you in the direction of that information. Mr. Parisi. And Francois, it also looks like there's, while you're looking for that, it also looks like there are some questions online.
Let me check again.
I'm not sure where the resident
Maple Avenue.
lives, but we
Right
are,
directly in front of
the town
Boardman.
requires that we be tower height setback from all abutting properties, which we handily meet from the three closest. And I think there's a measurement somewhere from Main Street.
Is it Maple Ave you said you were on?
Mhm.
Do you have something with a scale that shows Maple Ave?
You know what, I could probably measure if you, I'm just gonna-
Maple Ave is a short street by the firehouse.
Nope,
Nope.
it's not. It's across the street from the old tea house. We're about halfway between the police station and the fire station. We're literally directly in front of this tower. This is why
You're
I
on
have
the other
such
side
a-
of the street.
No, I'm
You're on the school side?
on that side of the street. I am,
Yeah,
this tower is on 14 Main Street, but it is tucked back into the corner
Right.
of that property, which is directly behind my house. If my road didn't dead end and it kept going straight, it would run right into that tower.
but I
This
think
is
it's
why,
I think it's set, I
Where-
did go to your house and drove by, I took a list of everybody that complained, and I do believe it's over 1,000 feet.
okay,
So-
I need to know
but
these
he
questions
can-
because
Where-
I
he
can't.
can
We're
show
looking
you.
for you right now.
We're gonna tell you.
I don't have the exact, but when we did the site visit, we walked in this way and we walked pretty much straight, so it's pretty close to right here back on 14. And
Are you able to see the screen?
Are you in Maple Lane?
Yeah.
No, Maple Avenue,
Maple Avenue.
correct.
It's right there,
So I'm
there's
trying
a
to- is
street
this the
sign
house
that
right
says
there?
Maple.
And this is number 2?
No, 5.
5, thank
Five
you.
is nearer the street than.
Or is the line going to the right house?
I'm
So-
having a difficulty actually determining where this is.
this is the aerial photo. The yellow line is the distance from the tower site, and we're right now at 1,300 feet.
Can you just
And
let
where,
us know which
I
one's your
believe
house?
this is Maple right here, so
This
you're
one's my
right
house.
there. So the tower is approximately 1,200 feet back from that property right there.
Isn't there supposed to be a 1,500 feet setback
No, the
from
only,
roads and property lines?
no, the only
That's what I read.
setback was tower height setback, of which we meet.
I believe the applicant is appropriately stating that, Alice. You look like you would have thought.
Well, there's not a 1,500 foot setback for generally in town, I mean, it's a
Well,
huge
that-
distance.
There aren't many
But-
parcels where it's possible to do a 1,500 foot
okay.
setback. It's,
But it is in the bylaws of,
Are you talking about a specific cell tower, or a specific cell tower bylaw?
I need to find it, I'm sorry, I do have several things marked.
we're
I mean,
We're talking about
if
a
you
fifth
think
or a
about the
quarter of a
average,
mile.
frontage on a house is 200 feet. So this would be, and this is 1,200 feet. So it would be, you know, a considerable distance, and it would not be like in your backyard, you know, it's.
But it is in my backyard. It's very visible from my backyard, from my house, from
Did-
all of my windows. It's very
Well,
visible.
because we-
I have a very unique situation where my house sits really close to the house next to me, and so 90% of my windows face Babel Avenue and the behind,
I'm-
which face directly to this tower.
Right, please hold on a moment.
I'm
Francois?
I'm just stating the regulations here, which is section 18.4, and specifically .4.2, which is locations and setbacks. In section D, which I believe is the only one which does state some form of setbacks, says all communication facilities must be a minimum of 500 feet away from any municipal water supply areas. A waiver for this condition may be granted. That is the only setback that is actually stated here very explicitly, where there is some measurement that is specifically stated here.
I think the only thing she's saying is if her land, not the house, but her land goes all the way back, and she's questioning whether her boundary line is within the fall zone.
Well, I think one of the things we did cover, as a matter of fact, with Mr. Murray, was the fall zone, and validated and verified that the tower height, which I believe is it's 100 plus feet
149
with the
plus.
antenna at the very top, because I challenged you that the other day, and that the fall zone actually has to be 110%, so it's not just 100%, it's 110%, and that it actually did comply with the with that. So all communication facilities must be set back from all property lines and buildings for a distance at least equal to a height of 110% of a monopole, including any lightning rod, to ensure the safety of all abutters. The setback will be referred as to the fall zone. There is actually no mention of a lattice, but I would assume that as a result of the way that these are constructed, which is, again, a vertical structure, that a fall zone would apply similarly to a monopole as well as to a lattice structure. And so therefore, if this is 100 foot, 110% would be 110 feet. I think you go actually a little bit higher because of the fact that you have a lightning rod at the very top.
So it's 150 feet tall for the structure, and then a lightning rod at 156.
156, so
let's
you
do-
take 110%, that would be
and another 15 feet.
another 15 and a half feet.
Exactly.
So the total therefore would be 100, let's say round it up, 170 feet is what we're really looking at. And so if any property line, not just yours, any of Butter's property line is at least 170 feet away from the fall zone, that is pretty much the therefore it would comply.
Okay, I have another question about, I had questions about the runoff that I asked at the zoning board meeting, because I was very concerned about, proper runoff and if it was going to affect my property, because we already have high water and things like that. The reason why I bring it up again, and so I'm sorry, let me get my brain together, is because I would like to know, is this Mr. Murray the one who's doing the evaluation? Is he the one who's going to verify that Mr. Parisi's facts are in order and that things like the runoff will not affect my basement? Is that why there is another meeting for September 7th?
We,
Is that the person?
there is a
that-
drainage
that's the
calculation
thing?
that's presented. One of the things that we do typically engage a consultant for would be to look at the drainage calculation. In this particular situation, the key focus for drainage is actually onto the roadway from construction of the driveway.
Right, and I understand that, but I do believe that we have a valid concern that we already see a lot of water in our basements in the springtime, thaw, and anytime it rains really hard. Any kind of extra runoff
Where,
from a impervious structure, like a cell tower, and if it comes in our direction, if it's not gonna go down Brigham and you're gonna make sure it doesn't go down Brigham, where is it gonna go? It's gonna go in our direction, it's gonna add to the problems that we already have in our basement.
So-
And this is what I would like to know, if this is,
so to comment briefly on that,
Mhm.
we are absolutely gonna look at that.
okay.
There really isn't a lot of impervious structure we're talking about here. Our concern is primarily related to the driveway, but we have asked for a drainage calculation. We will review the drainage calculation. I think it's pretty unlikely that that's gonna be an issue that comes up in it, but we are certainly gonna look at it.
I'm also concerned about my home values diminishing because of the fact that my home will be so close to a cell tower and be very visible to a cell tower.
We have had some data presented related to that. I don't know if the applicant has additional data to present related to that, and we'll certainly talk about that more. But what has been presented so far is that that tends to be an issue in different settings than we're talking about here. But it's absolutely something we're going to look at, and it's something that we're gonna consider. Yeah, I think that's about what I can say about that at the moment. If you have compelling evidence, please present it, because compelling evidence is different from presenting a concern. We're all ears for it. I think if anything, I hope everybody took away from the room that we are very deliberate, to say the least, and for better or for worse from the applicant's standpoint. But it is what it is. We're all just doing our jobs here, but we're absolutely going to look at it.
I think there's one comment that I would like to make as a member of the select board, of the planning board, and also a resident of town. Anytime there is something that potentially would affect my own personal property, yes, there is a subjective evaluation that I can make out of this here. But the true value is when you can make an objective valuation of that. And that therefore would mean in your particular case, if you have some form of an evidence that you can provide to the board in terms of the impact that this may have on your property value, that would add value to your argument that the board can therefore take into consideration. And again, please understand, we're not even real estate assessors.
No, I understand, and
we
I'm just trying to bring up.
we understand subjectively what you're actually presenting here. But again, I look at the case law that you presented. I think there was some mention about this here, and it was actually presented as such. But again, not having hard fact and evidence in that particular case, basically made the court look at this here and say, well, present the evidence, and we don't have it here. Okay?
Yep, I totally understand that. I have
Okay.
another question about
Last one though, you're monopolizing time. And in
oh,
fact,
I'm
a
sorry,
few
if somebody
people
else
did
has
that
a question, they
already.
can definitely go ahead and I can wait.
Okay, anybody else who has not
I
commented?
have a
Oh,
quick question, on
yep.
the slide that was just up there, where it was showing some property groupings, I wanna know where the tower is on that slide,
Right here.
that's where it's going?
Can
Way
you zoom
back
out and
it-
show them where
Okay.
Main Street
Just-
is?
I was
in
gonna say,
relation
can you
to that?
show the
Yeah,
Google
where
map?
his
I
arrow
think that's
was.
a better,
He was pointing in with the arrow.
yeah, I think the Google
Yeah,
map.
I'm just
would-
looking at it in
the-
relation to
the
my property.
Main Street is
which
down
you can see
here.
looks like a backward L.
Yeah, Main Street is down here.
That's us.
The property, and the
The
property
tower's
is
way up there.
way in the back.
Not really, but I think it's a road that's gonna affect
Where's
that property
Brigham
more,
Street?
the road
The
will
road
go up
comes
there.
in this way
Because it's gonna
from,
be further up the street.
and the reason the road has to
We
come
didn't
in
get
this
that
way
at
is
the
it's all,
beginning.
as
It said
the
it was
woman
gonna be
mentioned,
there. You're right.
it's all wet in here. And there's,
Yeah, the tower's way up there, and we're down here, near the beginning of Brigham Street. But there's gonna be a road going up there. close
Yeah,
to us.
from Main Street,
Yeah, but where that
it
little
was-
square is somewhere, that's where the
it
tower's
was
going.
1,000 feet from Main Street. I know Alice
Yeah.
and
Well, this
Mr.
map's
Maxey
too hard to
both-
see.
both
Yeah.
looked at it.
the tower is back, way back.
Right there, way up there,
Yeah.
okay, so that's way, way up there.
It's very far from Main Street.
Yeah, it was
1200.
around 1,000 feet from Main Street.
My husband was worried about his garden.
I mean, this is, just looking at the GIS map at this point in time, and again, I don't have a position of what I'm seeing here. But if I take that little corner, if I may. Yep. If I take that little corner that you have here, which I believe is the last property
Yeah,
that has
that's
a
us,
residence
that
here,
backward
yes.
L, yeah.
to here, I calculate, this is just using the estimation that I see in the GIS, it's roughly about 500 feet.
The
From here to here. And it might be even more. This is just look at the GIS map.
But I thought the road was coming
That's
in
Maple.
7 and 9,
That's Maple.
which is further up. Oh, that's Maple. Oh, he's talking about
And-
Maple, okay.
Anybody else with first comments before we start talking about second? Anybody else on a first comment? Right, Ed, you've been waiting patiently.
Okay. I've been on the other side of the board where you are. My main concern is timing of, you've got the applicant who has stated that if we go beyond the date of September 1st, that it's probably gonna be litigation. The same exists for the planning, for the ZBA, because the ZBA is over 100 days, and they're supposed to make a determination with 100 days. And so therefore, I mean, we've got two situations where, we're gonna probably be in litigation unless he gets the answer he would like. And I don't think that's a good reason for ever considering a special permit. I think that if we have our zoning bylaws and he meets those, that's fine. If our due diligence needs to be done, we should do the due diligence in fairness to the townspeople and the abutters. And to work under the threat of litigation to two of our town boards, I think we need something from the applicant that says specifically that he gives us permission to go beyond the date in order for you to make an informed decision. And without that, you're just gonna look at litigation anyway.
Yeah. Well, I appreciate your comments on that. We're under a different statute from the ZBA.
Right.
And I'm not gonna comment on that because of the other discussions that are happening on that. I don't think it's appropriate for anybody on the board to comment on the ZBA's time limits. I can say that the statute for us is 90 days from the date of the hearing, and there's some ways to interpret that. We tend to interpret it conservatively from when we open the public hearing. There's people who've successfully argued that it's from when you close the hearing. I'm not gonna hold against the applicant that he's threatened to use court to exercise what he believes is his rights. By profession, I'm an attorney, that would make me a hypocrite. And simultaneously, we've suggested that, well, if we can't reach an order, maybe litigation is the correct thing. I'm not gonna entertain the idea of publishing somebody for threatening to assert their rights if they have a honest belief that they do have rights to assert. We're both just trying to do our jobs from opposite sides of the table.
Could I ask the applicant how he comes to the September 1st date versus the 90 days from filing?
I will, is that a question you would like to respond to? Okay.
Under federal law, you have to, the town needs to act within 150 days of the date of the application. We applied in April. The board didn't open the public hearing until July, but we applied in April. So, and I'll also tell you, I'm not looking for litigation here. I'm looking for a positive decision. You can consult with your own counsel, but what that 150-day limit allows me to do is assume a negative decision. And I don't want a negative decision, I want a positive decision. So I've expressed patience with the town, and but at the same time, if they're not gonna make a decision, I have to assume a negative decision. So, which is why I would be willing to extend the dates if the town were to approve the special permit, subject to site plan approval. Of all the things that we've heard tonight, the only thing that I believe is relevant, and I think the board agrees, is the drainage issues. And the woman that spoke with drainage concerns, that was made clear to me by the planning board very early on. And I look at your zoning bylaw, and not with respect to wireless, but the rest of your zoning bylaw. You have watershed protection, limitations, and I just wanna show you the site plans, because these are all the different lines that the town imposes on us. The circles are down here are the distance from the wellhead. These are the lines from the watershed protection district. These are the wetlands lines, and we've done yeoman's work to, our engineers to avoid wetlands, to avoid any impact. The town said, prove it, and we provided drainage calcs, and the town wants to get, independent corroboration from a professional engineer to substantiate that, and I agree with that. I am 100% confident that the woman's concerns with respect to drainage will be addressed, have been addressed, and the board will get satisfied with that. All the other issues, we're done.
Can we get back to my
We've,
original
we've,
question?
Just a moment.
we've satisfied the board, we've satisfied the bylaw. This is in a permitted zone, so the effect on property values, although we maintain, are none, are irrelevant to this board. That's not a criteria for a special permit. The town told us to come here by setting up the wireless overlay district. And we provided an immense amount of information to show that there are no alternatives. We talked about that at the zoning board the other night. So I believe we've provided a very compliant application. I understand the town has drainage concerns, and the runoff on Brigham Street was made very clear to us. The runoff to the abutting properties made very clear to us, and we are 100% confident that our engineers have satisfied and will satisfy your consulting engineers. Everything else is done, and so it would be really, I'm not threatening litigation. The town needs to make decisions, and I believe it has enough to make a decision on the special permit, with the condition that we still get site plan approval, which is obvious, because I need it anyways, so it's stating the obvious. But I believe the town has had ample opportunity, the public has spoken, the board has actually responded to address the concerns of the public better than I can. So I think the decision's been made, so make the decision, and then it'll be really easy to deal with Mr. Place and all those other issues. Because we have provided you with compliant applications.
Thank you.
I'd just like to submit to the planning board that I looked at the application and it's date stamped for May 20th, if that comes into play in terms of your time frame. And lastly, was there an environmental study done as required, and if so, can we get a copy of that?
Mr. Parisi?
I believe the bylaw, and don't quote me because I'm got so many different bylaws in my head, is that if there was a environmental assessment, an EA under federal law, that we would provide it to you. There is no EA required, so we don't have to provide it to you. It's not required. It's only in the instance where we have an impact on environmental issues, and we don't, by avoiding all the wetlands, by avoiding all of the, which is why we went to the zoning board to avoid the wetlands. If the zoning board denies us, then we'll have to go to the Conservation Commission for permission to drive through the wetlands, which would have an environmental impact. So we believe we provided something that is far more environmentally compliant and does not require an environmental assessment under federal law.
Okay, thank you.
Can I just ask, do you happen to have the quote, is it a quote of Mass Federal Regulations, that statute of limitations?
No,
The 150 days, where does that come
it,
from?
I'll get you the exact site. They're called the shot clock regulations. If you Google shot clock, it's the first things that come up.
So these are federal procedures, administrative
yeah,
procedures, where does this come from?
It is procedures adopted by the FCC as authorized by Congress.
But it's not part of FCR, Code of Federal Regulations? No?
No, it's, I'd have to look to get you an exact quote. I can get you exact quote. Let's see.
Cause usually every FTC, I'm not real familiar with federal law, but most FTC law, most agency law is in the regulations, right? But I guess maybe they could have administrative procedures, it's not something I'm aware of.
Yeah, I'm gonna give it to you right now. It's, the Federal Telecommunications Act, section 332, subsection C7B.
Can you give that to me one more time?
It's the Federal Telecommunications Act, section 332C7B, and the Federal Communications Commission's shot clock regulations adopted pursuant thereto.
Okay, but for the record, for some protection for us, you agree to extend this at least to September 7th to give us a chance to resolve these
No,
issues.
I did not say that. I
No?
said, if the board would make a decision tonight, on the special permit, I would agree to extend the requirement to make site plan approval decision.
That sounds a lot like extortion.
Please.
Um,
I'm sorry.
I'm trying to avoid litigation. I've made that very clear. We've been very patient. And from my perspective, the town keeps giving me more bills and does not seem any closer to making a decision. Because we're not making a decision on September 7th. We're simply talking to our consultant. So then we're into October before we get a decision. And I would agree to extend deadlines if the board was willing to work with us. I've been patient. So I believe that the board has certainly enough information to make a special permit. If you wanted to approve the special permit with conditions that were to be discussed pursuant to your bylaw at the next meeting, we could deal with that. And I could provide you with a form of decision. That we've done this in dozens of other towns. And although those towns aren't interpreting your zoning bylaw, it's very easy to craft a special permit decision.
Well,
And I just think
I'm
that.
gonna suggest a 10-minute recess, and I'm gonna attempt to get ahold of town council. Anybody on the board have any objection to that?
No, make a motion for a recess.
Yes, do we have?
Can you second that?
Is it, I just don't wanna
Do we
run
need a
afoul of
motion for
open meeting laws or whatever,
Or
is
do
it?
we have to?
Just a recess
I think
for the
you can
sake
go
of
into,
the-
you can go into executive session, I think, is that what you
No,
want?
we
Is
cannot.
it you wanna
go
do
into-
that, or
no,
you just
no,
wanna
it's not an executive
take a
session.
break?
I
'Cause it's-
think we can just go into recess.
You can take, yeah, I'm just
Because
asking
we're
for a
not
recess.
closing or continuing.
Yeah,
And
So
just,
it's
and
just-
hold a discussion.
continue.
Well,
with-
no, I'm going to step out and try to get ahold of town council,
Okay.
and get ahold of town
I just don't think we
administrator.
can deliberate without the public here, but we could take a recess if you wanna make a
Yeah, I'm
phone
just
call
gonna
as
try
the
to make
chair,
a
I
quick
think.
phone call.
Good luck. That was a joke.
Yeah, I guess so. Or wrong.
The balloons flying.
June 7th.
Thank you.